Welcome back, everybody, to the 14th Annual Competition Conference. We're moving into the academic session now. It's the third academic session of the conference, and it's going to focus on merger control. We're running just a little bit behind on time, so we'll run the session from now until 1:15, which is when we're going to break for lunch. Again, let me say that we went through many papers that were submitted and selected the best quality papers for you for this session. These papers really are of a high quality, and we hope that you're going to enjoy the session. If you would like to ask questions of the panelists, please can you use the chat function? It should be at the bottom of your screen. We'll try to get through the questions as best we can. So let me introduce your moderator and discussant now. Dr. Rina Dasnayer is a senior researcher at the Center for Competition, Regulation and Economic Development. She's also a senior lecturer in the master's program at the University of Johannesburg. This is just a really short introduction to Rina, but you'll find her really impressive bio on the chat section a bit later in the session. Rina, can I hand over to you now?
Thanks. Thank you, Nandi, and thank you to the Competition Commission for inviting me to be a discussant in this very interesting session. I'd like to say a very few words before I introduce the speakers, and just to welcome everybody to the session on merger control, merger thresholds, and the failing firm. The papers in this session, as Nandi mentioned, are of exceptionally high quality, and they raise very important debates on the challenges that competition authorities are facing and are likely to increasingly face as a result of the economic crisis. We know that many businesses have been the casualty of the lockdown, and those that have survived with some form of temporary support from government and other sources face enormous challenges in recovering and growing once that support ceases, not least because of the depressed demand that they're going to face. So this is likely to translate into more failing firm defenses being put up in mergers that are filed at the Competition Commission. And in turn, this puts pressure on the competition authorities, not just in terms of resources, but also about the principles and the frameworks that they're going to use to analyze these measures to ensure that the correct outcomes result. And all of this is against, of course, a backdrop of a very severe economic crisis. And this is a challenge, as you'll hear the presenters speak, that is not just faced by South African competition authorities, but worldwide, as they weigh up whether they should continue with the stringent tests that have been previously applied under the failing firm defense, or whether there should be some changes, and indeed what those changes should be going forward. So 3 of our 4 presenters today will be discussing this topic in a lot of detail. Related to the increasing pressure that the competition authorities will face in merger evaluation, our 4th presenter will discuss the importance of setting the right merger thresholds, especially given the surge of mergers that may be coming the Commission's way. And this, as you can imagine, is a very delicate balance to ensure the optimum merger thresholds that reduce the burden on the Competition Commission without compromising stringent anti-competitive evaluations and assessments. So without raising concerns of under or over enforcement. And with that brief introduction, I'd like to introduce our speakers. We have first Kriska Leila Gulabjit. Kriska is legal counsel in the Legal Services Division at the Competition Commission. And Kriska's paper, which she has written with Romeo Kariga, is on failing firms and the evolution of the failing firm doctrine in South African competition law. After Kriska, we have Tabiso Pozwa. Tabiso is a graduate trainee in the Economic Research Bureau, and his paper, which he has co-authored with Kalirendwe Rananyeni, is around failing firms, business rescue, and reorganization and antitrust. Third, we have Kalirendwe Rananyeni, who is a principal economist in the Economic Research Bureau, and she has co-authored a paper with Tabang Ndlovu and Samantha Key, and the paper is around mergers in a failing industry, a case study of the ostrich merger. Last but not least, we have Samantha Key, who is also an economist at the Economic Research Bureau, and she has co-authored a paper with Rehma Luna, Yongama Njisani, and Sibuyise Mtiki, and this paper is around merger thresholds determination. So with that introduction, I'd ask Kriska to start with her paper presentation. Thanks, Kriska.
Thanks very much, Rina. I just want to share PowerPoint, but I The host has disabled me from screen sharing. I'm unable to share. It's fine, I'll just continue. So I'm presenting a paper that was written jointly by Romeo and myself on the doctrine of the failing firm. And just as a disclaimer, it reflects our personal views and not those of the Competition Commission. As most of us in the competition law sphere are aware, the doctrine of the failing firm has been discussed by competition regulators and stakeholders globally due to the COVID-19 pandemic, both from an administrative and substantive assessment perspective. The common theme being that there will be no relaxation of the stringent application and high evidentiary burden on the merging parties in the approach to the failing firm doctrine. Our paper explores the evolution of the failing firm doctrine in South Africa, its origins, how it has been incorporated into our jurisprudence, and how it has developed. By tracking the case law over the last 20 or so years, we have identified an opportunity for the doctrine to undergo a change in approach or application in order to better accommodate and enhance its effectiveness under the current legal framework in South Africa. The paper suggests and explores some measures of change to the approach, the doctrine, ranging from conservative to radical recommendations. So to go back to the origins and to set the scene of the failing firm doctrine, the United States was the first jurisdiction to recognize and apply the failing firm defense. In the USA, it is invoked by merging parties as an absolute defense to an anti-competitive merger. In other words, if the merger impedes competition, but one of the parties is a failing firm, the merger should still be approved. The US Horizontal Merger Guidelines provides guidance on how to assess a failing firm. Firstly, there should be an inability to meet financial obligations. Secondly, the inability to reorganize successfully under their Bankruptcy Act. Thirdly, unsuccessful attempts to solicit reasonable alternative offers to pose a less severe threat to competition. And finally, if the merger does not proceed, that the assets of the failing firm will exit the market. The EU has largely followed the lead of the USA. It is also an absolute defense. The basic requirement in the EU Horizontal Merger Guidelines is that the deterioration of the competitive structure that follows the merger cannot be said to be caused by the merger. There are three cumulative criteria to be met, and the nuance between the US and the EU is that the EU has taken a more stringent application and restrictive interpretation of the doctrine. The failing firm has to prove that it would be forced out of the market. The EU has dealt with a handful of cases, and these are referenced in our paper. Other jurisdictions have largely followed the same approach of the US and EU with slight variations, but those are not material as the doctrine largely remains the same. Moving on to South Africa, Section 12A2G of the Competition Act gives statutory recognition to the failing firm doctrine. It is not a defense. It is a factor to be considered in the overall competitiveness assessment of a merger. What can be gathered from our review of the case law is that the South African competition authorities are inclined to balance interests as opposed to applying rigid formula. In other words, the assessment and application of the failing firm doctrine is flexible in the South African legal framework. The onus is on the merging parties to provide evidence to support their reliance on this doctrine. The leading case reflecting the tribunal's incorporation and treatment of the failing firm doctrine in South Africa is that of Iscor Saldanha. The tribunal set out a 7-point criteria that provides guidance on the current legal approach. Unfortunately, due to time constraints, I won't be able to traverse the criteria, but it appears in full in our paper and in our slides. However, our paper also demonstrates how the criteria set out in Iscor has been applied in various mergers following that decision. And in tracking the case law for the last almost 20 years, the main guidance gleaned on the doctrine and its application in South Africa is the following. Assessment is on a case-by-case basis, taking into account the specific facts of merger and what evidence has been presented. It is not only the merging parties that can raise the failing firm doctrine. If a firm is in de facto liquidation, it is a failed firm. Financial decline or distress does not equate to a failing firm. It is not necessary to show that a firm has already failed. Evidence is key to substantiate likely failure. Failure also need not equate to insolvency. And finally, alternative offers to purchase need to be on the table at the time when the merger transaction was concluded and not at some indeterminate time in the future. The paper provides more details on the cases that illustrate the principles that I've just gone through quite quickly. And just to summarize the requirements in South Africa for the failing firm doctrine to have application, and this has been drawn from the jurisprudence that's fully explored in our paper, the following factors must be proved cumulatively by the party raising the doctrine. Firstly, that the firm is likely to fail or has failed. Secondly, other alternatives to save the firm were properly exploited before the merger was concluded. Thirdly, there was no alternative purchaser that would result in a less anti-competitive outcome. And finally, that the assets of the failing firm would exit the relevant market absent the merger. Moving on to the counterfactual, the analysis of the counterfactual is essential in assessing whether a firm has failed or is likely to fail. In failing firm scenarios, the counterfactual is as follows. If a party to a merger will, but for the merger, inevitably exit the market in the short term, the merger can have no adverse impact on competition. The CAC has made it clear in the Pan-Seed merger that a blind eye cannot be turned to the reality of a situation when developing the relevant counterfactual. This reflects that a counterfactual can only be developed on the facts and evidence on hand. In the recent Senvest merger, there was disagreement on the relevant counterfactual between the Commission and the merging parties. The reasons for decision are still to be issued, and we are eagerly awaiting to read the Tribunal's stance and reasoning on the counterfactual. Romeo will speak to the counterfactual issue in more detail during our discussion session, given his hands-on involvement in this merger. And then just going on to our recommendations, which form the crux of our paper. Firstly, we are of the view that the Commission, as an immediate and direct response to the pandemic and failing firms or firms that are likely to fail, could place more weight on the failing firm factor in the Section 12A2 assessment, given the context of the impact of COVID-19 on the already dire state of the South African economy. And in doing so, the competition authorities will need to take account of our hard lockdown and the staged reopening of various sectors. So industries have been affected differently. The impact of the pandemic and recovery will be nuanced. And then public interest considerations become key. And this may be a more appropriate manner in which to assess the effects of the failing firm, for example, employment. As a stakeholder in government economic policy, the competition authorities will have to be aware of how its merger decisions will affect the policy of rebuilding the economy and how approving a merger on this failing firm doctrine will create a future in that sector of the market in the long term. The economic agenda of the ministry and ultimately the presidency should also be considered. There are bigger interests at stake than just rigidly applying the failing firm doctrine. Secondly, our position is that the timeframes for assessment should not be shortened. This could really lead to unforeseen and undesirable longer impacts in the market. The failing firm factor cannot be used to address short-term difficulties. There needs to be a history of financial demise and evidence to support this. So we go on then to explore a more proactive approach, which is a suggestion for the Commission to issue guidelines in terms of Section 79. For example, this could provide guidance on the evidence to be submitted and how a merger that relies on this failing firm doctrine will likely be assessed. Guidelines will give a level of certainty and comfort to the merging parties as to what information to provide upfront, which could be more efficient in terms of the process with the Commission and its assessment. Cooperation on the provision of the information is key in order for the Commission to conduct its vigorous and rigorous assessment timeously. This recommendation will obviously require robust stakeholder engagement. We then explore a more radical approach, which is for the Minister to issue regulations in terms of Section 78, which would allow perhaps a less stringent evidentiary burden to raise the failing firm doctrine for a predetermined period, pandemic-specific, which timing would be premised on predictions of anticipated recovery of the economy in various sectors and industry. Again, going back to the hard lockdown and the graded reopening of industries in our economy. So the regulations could list the bare minimum evidence that would be required to be placed before the competition authorities and set a reasonable time in which the target firm should approach viable purchasers, given the urgency of the financial distress and the ultimate failure of the firm. The proposed regulations could also address the issue of government funding, to what extent this has been or should have been utilized. And again, we are well aware that this recommendation would require robust stakeholder engagement. And then finally, the most radical recommendation is to amend the current legislation in order to better clarify the legal tests to be met and set a statutory standard contextual to the South African economy for merging parties. This would call for an in-depth engagement with the already well-established tests in the US and EU, as well as other jurisdictions, in order to determine what would best suit the South African legal landscape. Again, policy issues and high-level governmental strategy for the economy, as well as the agenda of the presidency in relation to rebuilding the South African economy, would have to be taken into account. Over and above all our recommendations, we must always refer back to the preamble and the objectives of the Act in order to best achieve its purpose and aims. And then just in conclusion, it is not all doom and gloom for fading, flailing, floundering, and failing firms. There's definitely certainty and guidance in the current jurisprudence on the legal criteria and tests to be met, the evidentiary burden, and the owners. From my exploration in the paper of the case law, it does appear that assessments are conducted on a case-by-case basis, taking into account specific facts and evidence. Secondly, there's a balancing exercise between the failure versus the anti-competitive effect of the merger. And finally, that the application of the doctrine is dynamic and flexible. The gist of our paper centers around the distinguishable feature of the failing firm doctrine, that it is not an absolute defense in South African law, but merely a factor in the competitiveness assessment. Therefore, in conclusion, our paper calls for a revolution to the approach of the application of this doctrine in order to better accommodate and enhance its effectiveness, pandemic or not. And if you have any queries, suggestions, or comments on our paper or slides and wish to engage further, our details appear on that last slide. Thank you very much.
Thanks, thank you, Kriska. And I think it was a very insightful paper. I'll provide my comments at the end of the session. And thank you especially for sticking to time. As I call upon Thabiso to put his presentation up, I just want to remind the attendees to post any questions or comments in the Q&A box on the screen and not on the chat function. Thank you. Go ahead, Thabiso, thank you.
Hi, thanks very much. Thanks, Trina. Just thanks to the panelists and everyone just for being here and having us. Just firstly, I'd just like to say that I've elected to have a discussion as opposed to a PowerPoint presentation, just given the time constraints and limitations, and just wanted to just highlight some of the major themes that are discussed in the paper. Now, it's just important to note that given financial and economic crises and difficulties, liquidations and insolvencies tend to increase. I reference the 2008-9 financial crisis, whereby we saw that both liquidations as well as insolvencies increased during that 2008 to the 2010 period. Now, it's therefore anticipated that increasingly firms will be filing mergers under the failing firm defense. Now, Kriska has done a fantastic job in detailing the evolution of the failing firm defense, and so I won't go into much detail about that, just the history of it. But the paper does discuss both the US criteria as well as the EU criteria and mechanisms that are required to be met when relying on the failing firm defense. However, I just wish to point out that both the US as well as the EU jurisdictions, the failing firm test, the criteria is more or less similar if you look at both the criteria, just in that it's similar, not exactly the same, but it's similar. It's just that under the US guidance, there's an additional criteria there that speaks specifically to reorganization. Now it needs to be shown that that reorganization of a firm would be unsuccessful. And that's a requirement that's not really there in the EU, under EU guidance. Now, paper that I wrote with my co-author Kalirendwe Raninyeni also makes mention of cases that assisted in shaping how failing firm mergers are viewed in South Africa, namely the Iskor Saldanha Steel case, as well as the Santam Emerald merger. Now, these cases are important because they spell out just the requirements to be assessed, which include reorganization, the reorganization criteria as listed based on the US criteria. Now, the paper that I wrote with my co-author provides has illustrative examples of recent merger filings that were assessed by the Competition Commission for firms relying on the failing firm defense. The three cases are the Sadevest Bell transaction, the Kind Choppies SA transaction, as well as the Alroad Vardex transaction. Now, the test stance that my co-author and I chose to adopt was the US stance, and just based our criteria based on the US, since it was more criteria to be met. Now, what you'd find that just in assessing those mergers, we find that competition authorities or the Competition Commission has done an exceptional job with regards to most of the criteria. I could just take you through them with regards to the first criteria, the alleged failing firm being unable to meet its financial obligations in the near future. Now, there the Commission has done fantastic in that it's gone on to look at financial metrics that point to the likelihood of a fail being unable to meet its financial obligations. More so, it's Commission also adopted an approach whereby they don't just look at ratios just for the sake of looking at ratios, but they actually look at the meaning behind the ratio. It shows great understanding of the finance behind that. For instance, if you look at the financial obligation, now financial obligation, according to international financial reporting standards, speaks to liabilities, which would require an assessment of a firm's gearing ratios. But both short-term and also long-term, more so long-term, if you look at gearing ratios, such as your debt-to-equity ratios and the like, short-term ratios such as your current ratios, your asset test ratios, they're also good in assisting in just trying to find out whether the firm is failing in the short run, or the substantiality of the financial distress or obligation of the firm. Now, in terms of the second criteria as well, unable to whether the firm has made unsuccessful efforts to source alternative efforts. Now, the Commission has gone and looked at alternative bids, and as well as in the Alroad Vardex merger, the Commission is as far as just assessing the values of the offers that have been posed. Because it's one thing getting an offer, but then it's something else when you actually interrogate the value of that offer, whether the offer is competitive in itself. For example, you might find that a firm is valued at between 100 million to 120 million. But then if you get an offer for 200 million and you have to compare that to an offer from a smaller player that's more closer to the fair value points, you might find that it assists in interrogating the competitiveness of the offers. Now, also just another point that my co-author and I assessed was whether the assets of the firm would exit the markets. Now, my co-author and I found that that's the criteria that most firms have struggled to meet. We found that it's difficult to meet that criteria. For instance, in the Sadevest transaction, those were silos. Now, grain storage, some assets are for use, particularly within a certain markets or within a sector or market structure, and it's unable to exit and be used for anything else other than, for instance, grain storage. Now, what my co-author and I also found was that the reorganization criteria has gone unassessed, or hasn't been. Merging parties haven't always provided and haven't mostly spoken to reorganization And we understand that the reorganization criteria speaks a lot to the bankruptcy acts in the US, and that doesn't apply to South Africa based on jurisprudence, based on jurisdiction, my mistake. However, if you had to be that strict, you could similarly look at the Companies Act, which Makotha and I mentioned. We look at similarities between both the Companies Acts, particularly Chapter 6, Business Rescue, and we compare that to the Bankruptcy Act. And we find that there are lots of similarities. For instance, just in terms of the objective of reorganization, rehabilitating a firm so that it continues to operate as a going concern, the enlisting of a business rescue practitioner, as well as voluntary and mandatory business rescue filings. Now, the paper further goes on to list additional sources of evidence that are available to both merging parties as well as competition authorities, just to assess, just to look at in terms of assessing whether a firm has indeed gone and tried to reorganize. For instance, we make reference of International Financial Standard IFRS 13, which is a standard on non-current assets held for sale and discontinued operations, which directly speaks to the measures and mechanisms that identify whether there has been any sort of reorganization or attempts to reorganize. And yes, we also speak about IFRS 5 as well, just in assessing alternative buyers, just to look at the competitiveness of those offers that have been presented. So yeah, that's pretty much just the key points that have been raised in the paper that I wrote with Kali. And thank you very much for your time.
Great, thanks very much, Thabiso. Some very important points raised about certain areas or areas of assessment that have been, I'd say, underutilized or sort of not given the kind of limelight as they could, and it certainly points towards strengthening the provision going forwards. If we could move on to Kali next and go straight into the third paper.
Thanks, Rina, and thanks everybody for attending this session. The paper that I wrote with other colleagues of mine is titled Mergers in a Failing Firm, a case study of the ostrich merger. This paper was co-authored by Samantha Key and Thabang Ndlovu, and I'd like to just put a disclaimer that the views contained in this paper are our own and not that of the Commission or of RBB Economics. The paper really had two objectives. The first was to start a debate on the extent to which competition authorities should sympathize with firms in failing industries. The second objective was really to illustrate two tools, specifically the different pricing pressure models that competition authorities could rely on when presenting such cases to the tribunal. So as I said, the paper is really a case study of the ostrich merger, and I'd like to give a brief background of the merger. So this was a merger between Cape Karoo, Klein Karoo and Mostrich, which was notified on the 22nd of August, 2018. After a detailed assessment, the Commission prohibited this merger, after which the merging parties filed an application of consideration to the tribunal, and the tribunal approved this merger with conditions in mid-August 2019. So this paper was a very good case study, especially for this topic on failing firm and failing industry, particularly going to Kriska's paper that talks about the counterfactual. In this merger, it was common cause between the merging parties and the Commission, and actually the tribunal also noted that there was a significant decline in ostrich volumes since 1993. There'd been a large exit of ostrich farmers. It was recorded in 2011, for example, that there were 400 farmers, whereas in 2018, there were only 200. There was also a drought in the Karoo that also contributed to the exit of farmers, and also an avian influenza that affected the industry by bans that were imposed on export of raw ostrich meat, which also limited the production of ostrich meat. So it was common cause that this industry was in some sort declining. However, what the dispute was with the counterfactual, in that the merging parties' view was that the parties would eventually exit as they were in a declining industry. There was no evidence on financial distress on either of the parties or any of the firms in the sector. So there was no way the failing firm test, as highlighted by Kriska or Tabiso, would have been successful on any version. Neither of the criteria would have worked. As such, in its decision, the tribunal conditionally approved the merger, and it noted that the conditions in the industry, so the drought, the decline in ostrich volumes, the exit of farmers, contributed in its decision. However, it wasn't clear how that falls into the assessment of merger control. So as a result, the paper wishes to start a debate on exactly how should competition authorities be thinking about mergers in a failing industry where the firms themselves are not failing. Is this part of the counterfactual, or is there somewhere else where competition authorities need to be creative in bringing this into the assessment? So the paper goes into case precedents, trying to understand, had there been similar transactions in the past and what had competition authorities done? We found the CDT merger where the industry on CDs had been declining. However, the nice thing in that merger was that the one firm was in financial difficulties and it was easy for the merging parties to meet the criteria. So that was still different to the case at hand. So I think what the paper really tries to do is to say competition authorities should not use the failing firm defense loosely. And in that we mean we shouldn't be approving mergers in failing industries, sympathizing with them, using merger control, as that changes the structure of the market permanently. And we should rather be using other instruments or other policies, instruments such as exemptions, policies such as industrial policy, to address any temporary distress that firms in failing industries may be facing. The paper also went into detail and provided some empirical tools that authorities could use to strengthen the evidence on anti-competitive effects, and these are the GAPI and the UPP. I won't go into detail of what the assumptions of these are, that you can find in the paper, but in a nutshell, the results we found were that the UPP estimates were positive for all parties and for all efficiency parameters, which means in interpretation that there's a likely unilateral effect that arises from the merger. We did this by ostrich meat, we did this by ostrich meat cuts, as that was a big debate in the case. We also looked at the GAPI, and similarly, the GAPI also supports the results of the UPP, in that all the GAPI estimates were positive and greater than 25%. And this was also considered by ostrich meat as a market, and also considered by ostrich meat cuts as a market, as that was a big debate in the case. So I think, just in conclusion, as I've said, the paper really argues for competition authorities to be more vigilant than ever and not sympathize with merging parties on the basis that they're in a declining industry, because industries are going to be declining, and that is usually because of a temporary structural break that brings temporary distress, and markets will always go back to their competitive nature. Thank you, Rina.
Thanks very much, Kali. I think that brings in a sort of slightly different perspective from the first paper that warrants a different treatment of the failing firm doctrine. So this will make for good debate at the end of the session. If I can call upon Samantha to present the last paper on merger thresholds.
Good day, everybody. Today I will be presenting a paper on merger threshold determination on behalf of my colleagues and co-authors, Yongama Njasane, Rahma Lerner, and Sibuyise Mtiki. Before I begin, I'd like to note the following. The views, findings, and recommendations expressed in the paper and presentation belong solely to the authors and do not represent those of our employer or any other institutions that we belong to. So, mergers and acquisitions, by their very nature, tend to permanently alter the structure of markets by enabling firms to acquire market power or by distorting competition. In this context, an important feature of many jurisdictions' merger control policy is the appropriate determination of merger notification thresholds. In this respect, the primary objective of this paper was to identify the impact on institutional efficiency and effectiveness of South Africa's merger notification thresholds, by specifically looking at a sample of notified mergers to the Competition Commission. First, we evaluate the current thresholds in limiting the occurrence of type 1 error costs, which we view as a proxy for institutional efficiency, as well as limiting the occurrence of type 2 error costs as our indicator for institutional effectiveness. Type 1 errors refer to the costs that amount to a wasteful use of institutional and third-party resources, that is the human and financial capital required during notification and investigation whenever a non-problematic, sorry, I think my slides are only sharing now, sorry. So type 1 errors, so it's the wasteful use of scarce resources whenever a non-problematic merger is notified. In terms of type 2 errors, these are those costs related to the loss of consumer welfare whenever a problematic merger transaction goes unnotified. For the main analysis of our paper, we evaluate the likely impact on South Africa's merger control regime should the current thresholds be changed. We base the changes on a scenario-based benchmarking approach. The benchmarking exercise consists of a cross-country comparison, as well as a historical comparison based on the past experience of the Commission. I won't go into too much detail on the cross-country comparison, just for the sake of time. However, I would like to acknowledge the World Bank Group, who provided their threshold estimations, which are used as one of our scenarios. Next, I'll briefly highlight South Africa's current and historical thresholds, as well as how mergers are classified. The two tables show the merger thresholds and filing fees over time. The red font below represents the current merger thresholds and filing fees. So in terms of South Africa, merger thresholds are based on either the annual asset and turnover values generated by the target firm and the combined firms. South Africa also makes use of two different threshold values, a lower and an upper value for both the target and combined firms. In terms of the lower threshold, this determines whether the notifiable merger will be classified as an intermediate merger, and the upper value or upper threshold determines whether the merger will be classified as a large merger. The Commission also has a classification for a small merger, where small mergers are voluntary or notifiable at the request of the Commission. In terms of the merger filing fees, these are only applicable for large and intermediate mergers, which generates additional resources for the Commission. Notifiable mergers are also further categorized by the Commission based on the complexity of the merger. So the Commission has 3 phases in this regard, where phase 1 mergers are not complex and deemed unlikely to give rise to anti-competitive effects. Phase 2 mergers are complex with some overlap between the merging parties' activities and may give rise to competition and public interest concerns. And phase 3 mergers are defined as very complex and require a more in-depth review. In terms of the efficacy of the current thresholds, we evaluated a total of 1,080 mergers notified over the period 2016 to 2018. Given the current thresholds were implemented from the 1st of October onwards, it does not have an impact on those mergers notified after that date. You'll see from the figure on the right, the changes to the notifiable intermediate mergers adjusted for the current thresholds. The table below shows the outcomes of these non-notifiable intermediate mergers, where a total of 53 intermediate mergers would not have been notifiable, 49 were approved, 3 approved conditionally, and 1 prohibited that would not have been notifiable. From this, we concluded the current threshold adjustments appear to have resulted in few negative consequences in terms of type 2 errors, given the few problematic mergers that would be non-notifiable, while type 1 errors continue to persist, given the few approved mergers that are lost. Next, using the adjusted period based on the current thresholds, we evaluated the number of notified mergers that would be impacted by a change to the current merger thresholds. The point of this analysis is to determine the most appropriate thresholds that would likely result in the reduction of notifiable mergers to the Commission, without limiting the number of mergers with competition and/or public interest concerns from escaping merger control. The table highlights the scenarios that we looked at when evaluating the potential increase to the current thresholds. We looked at 4 broad scenarios. So in terms of the first scenario, we looked at an increase to only the target firm's thresholds, where we increased the target firm's threshold by 5, 10, 15, and then 20%. Second, an increase to only the combined firm's thresholds, by increasing it by 10, 20, 30, 40, and 45%. And third, we looked at an increase to both the target and combined firms thresholds by a 15% increase to the target firm and a 20% increase to the combined, or a 40% increase to the combined firms. Fourth, we used the World Bank Group's proposed thresholds to only the intermediate merger thresholds. They provided 3 different estimations. In this regard, it's important to note that the World Bank Group estimates are substantially higher than our more conservative scenarios. Our general findings show that there would be a slight decrease in notifiable intermediate mergers across our various scenarios. For example, between a 2.3 to a 9.3% drop for an increase to only the target firm thresholds, up to about a 14.6% drop for a 15% increase to the target and a 40% increase to the combined. Most of the intermediate mergers that are dropped were approved unconditionally, with a few which were approved with conditions abandoned or were withdrawn, and with our scenarios, none were prohibited. However, this picture changes when we assess the impact of the World Bank's estimated threshold increases, which leads to a number of intermediate mergers that would be non-notifiable, with many more problematic mergers that are dropped under the scenario. Under each scenario, we took a closer look at the problematic mergers that would no longer be notifiable. That is, we looked at the mergers approved with conditions, abandoned, withdrawn, and prohibited. For this, we specifically looked at the conditions applied to the conditionally approved mergers, as well as the phase of the merger and the sector in which it impacted. Our findings show that many of the mergers that were conditionally approved had mainly public interest concerns related to employment, while the others with competition-related conditions involve both structural and behavioral conditions such as divestment, restraint of trade clause amendments, local supply procurement type conditions, and conditions relating to information exchange. Lastly, we also evaluated the potential impact on the Commission's revenue generated from merger filing fees. I won't go into great detail on this, but reducing the number of notifiable mergers could have a big impact on the Commission's budget. And based on our 2016-2018 observation period, the Commission would have to maintain would have to increase its filing fees quite significantly to maintain the same level of revenue during that period, which in itself may place further constraints to business. But this is highlighted in greater detail in our paper. Lastly, so to conclude, our overall findings suggest that few problematic mergers would not be notifiable under our tested scenarios based on the 2016 to 2018 observation period, although our scenarios do suggest a reduction in type 1 errors with few type 2 errors incurred. It is still, however, important to point out the limitations of the benchmarking approach, this being the reliance on historical data, which we acknowledge is not representative of the current reality of the unprecedented times that we are living in. This is especially true given the sustained decline in South Africa's economy, both prior to and from the COVID-19 pandemic. That is, if we consider the current economic climate and the impact of COVID-19 pandemic on business, the Commission is likely to be inundated with far fewer but more complex merger transactions going forward. In addition, many of these transactions may fall under the current thresholds as businesses seek to divest non-essential operations or perhaps even exit. In terms of this, it is warranted to perhaps err on the side of caution and take a more conservative or alternative approach to reforming current merger thresholds as to not distort competitive dynamics and ensure that competition and public interest can be enhanced or maintained for future. This is especially dire given that many sectors in South Africa are highly concentrated. So our recommendations from our study or our paper are as follows. We propose the development of a sector-based threshold. So for instance, for specific designated sectors, we could look at having a separate threshold for them, especially those that might raise competition concerns. Competition authorities may also look to introducing alternative metrics, such as the setting of the adoption of a transaction value-based metric, where the actual purchasing price of the target company or assets are used as part of the thresholds. This is especially useful for merger transactions where assets and turnover values of the companies are too low to trigger mandatory notification, but the transaction may have significant competition effects. An example of this is, for instance, the digital market space. The Competition Commission may also look to adopt a more stringent and robust initial merger screening mechanism to identify early on those mergers that would not be problematic versus those that would require more in-depth review. In addition to this, the competition authorities may also look into amending the allocated merger investigation period by extending the evaluation times on mergers that are more complex, that is based on the phase of the merger, regardless of the size, which is our current practice. So that wraps up our presentation. Thank you, Lina.
Thank you, Samantha. If you could just share the screen, that would be great. Thank you. So while Samantha does that, first, a very big thank you to all the presenters and for the papers. The papers are so rich with so much detail and so much information. It's just not possible to do it justice in 10 minutes each. So well done to the presenters for bringing together the crux of the papers. And I think the participants would really benefit from reading the papers. They are really very detailed and very thorough. So with that, I would like to have a little bit of a discussion on each of the papers. So it's in the form of comments on the papers, as well as posing some questions to the presenters, as well as the other authors. And then we'll give a chance to the various presenters or the other authors to respond to some of those comments and questions. And then lastly, we'll take some of the participants' questions. So starting with the first paper that Kriska presented, I think this is such an excellent, very thorough, well-documented record of the treatment of failing firm doctrine in South Africa. It talks about the origin, right through the evolution of how it has been applied, raises consistencies and contradictions that have arisen in the application over time. And I think it's an excellent paper to sort of refresh ourselves on, what has happened with the failing firm doctrine in the past few years. It also speaks extensively of the international application of the failing firm doctrine. And I think here is where the main debate arises. It's clear that several jurisdictions internationally have sort of noted that they're going to continue to apply the existing framework to assess failing firm mergers. And this, as the authors have noted, and in fact, the other authors have noted as well, is quite stringent. So there will be no relaxation of adjustments as a result of COVID. So what this means is that there's still a high evidentiary burden on the merging parties if this higher standard or the more stringent standard is maintained. The big question that the paper raises, of course, is this a good time for South Africa to take forward or change the failing firm doctrine in this sort of setting of the crisis? And how could it possibly do so? This is what the authors are trying to bring across. And they've listed, as Priska said, many conservative and a few radical approaches which the authorities can take. So in other words, the spirit of this paper is around a scope for the evolution of the failing firm doctrine. And I think this is very much in line with the sentiments that have been expressed throughout this conference, that competition policy needs to be more flexible and needs to adapt to situations, needs to adapt, of course, to countries or country-specific contexts, but also situations. So this paper, the spirit of this paper is very much in line with some of the other debates that we've heard part of this conference. I wanted to ask Priska, the heading of the paper, the title of the paper is around fading firms. And I noticed that the word fading doesn't appear anywhere else in the paper. So I wanted to ask her if that is synonymous to the concept of flailing firms, which is not a firm that's necessarily failing, but is a firm that's facing significant difficulties, which impairs their ability to effectively compete in the future. And I think it's important to make that distinction because it might call for a different standard in assessing fading or flailing firms relative to failing firms. But I think you mentioned that towards the end of your presentation, that you are kind of looking at it collectively. So just moving on to the measures that the paper suggests, and I think here are where most of my questions are. I think the first measure that the paper suggests is around giving more weight to the failing firm assessment under 12A. And I think that's fairly uncontroversial. I think that's something that our authorities and the paper very nicely puts forward. Our authorities have room to be flexible around how they treat the assessment of failing firms under 12A. The paper gives examples of what kinds of things that could be looked at in giving more weight to the failing firm assessment under 12A. Perhaps what might be a little bit more controversial is assessing or looking at the effects of failing firms under the public interest leg of merger evaluation. And I think this is an interesting proposition. And of course, we know that we're likely to be faced with a flood of mergers. And one of the main areas that is going to come up is employment. So the authors suggest that we might look at the public interest leg to deal with some of the effects of failing firms. But my concern here is that would this encourage opportunistic mergers, right? So if there is a perception that the burden of proof is somewhat lower in the public interest assessment, especially around showing employment implications, would you now kind of open the floodgates for very opportunistic mergers, sort of large firms swallowing up smaller players, etc.? And this links to the increase in the probability of type 2 errors or not prohibiting mergers that should be prohibited. And then I guess this also links back to the point of if we already have that flexibility under our section 12A, it might be just about using this flexibility a little bit more boldly. We can put a heavier weight on the assessment of 12A. And I think the paper very nicely shows how tribunal decisions have allowed for that flexibility. It allows for the balancing of the interests, and it's not about rigidly applying a particular formula. Then the paper goes on to talk about other types of interventions or other types of changes that might happen, and they talk about the temporary regulations, which Kriska mentioned about the DTI issuing temporary regulations specifically for the period under concern, with some projection looking forward of how long the difficulty that the firm or the industry might be in. Again, I think having that might increase the risk of, again, those kind of opportunistic mergers or increase the risk of type 2 errors, although I acknowledge that the authors do mention this in their paper. So we might have a phase or period of time where problematic mergers go through because of a less stringent assessment or a lower evidentiary burden. And this has long-term consequences on the structure of the market. And lastly, the paper talks about the radical approach, which is amending the current legislation to make it clearer what the tests are to be met under the failing firm doctrine. My sort of concern about this is that it might take away some of the flexibility that's currently there in the interpretation of the failing firm assessment under 12A, and having this sort of amended legislation might make it more rigid in a sense. So those are just some of the concerns or some of the points of interest, I think, that I have on this paper, and it would be good if the paper is being further developed to try and address some of these. Last, I guess this is a question that I'm posing to all three presenters who spoke about failing firms, and I think it was brought up quite nicely by Cully in her presentation, is just sort of going back a step to the international approach or the approach of international jurisdictions on failing firms. And I think internationally, as all the papers have said, the position is that this is not the time to relax merger evaluation. In fact, merger policy should be tightened rather than relaxed during the crisis. And the thinking behind that really is the firms that are struggling are usually your smaller players. And if these smaller players are sort of gobbled up by the bigger players, you have a bigger problem going forwards in terms of high levels of concentration and a much weaker competitive fringe. So the consensus that I see emerging in international jurisdictions is around other forms of support. And the kinds of support that have been raised are around state aid or government support for small firms to help them to kind of remain resilient as far as possible, as opposed to allowing them to have a recourse to the failing firm defense. And this kind of also prevents kind of eating up effective competitors and the implications of that in the long run. So my sort of broad question to all the three panelists that talked about failing firm, would this be a better solution or at least an alternative solution to ensure that the small firms survive? And like I said, Cully raised it in terms of the industrial policy tools that might be available to support small firms so as to not lower the stringent requirements for the failing firm defense. And this is much more from a long-term perspective. I think what I'll do is I'll go through the comments for all the papers, and then I'll let the authors give some responses to the ones that were specific to their papers. So moving to the second paper by Thabiso and Cully around, I think I'm just going to focus on the one area which I thought really popped out for me, and that was the kind of underutilization of a possible additional test or an additional tool in the South African situation. And that is around the question of the evidence around reorganization. And I think this is quite an important point, especially given the question that I just posed earlier, to ensure that there are no opportunistic mergers happening during this period. How can we use the tools that we have or tools that have been used in other jurisdictions, and in fact, tools that the tribunal has alluded to that might be important when we're looking at the failing firm defense. So in a way, a little bit in contrast to the first paper, it's more about how we can use the existing framework as it is and how we can strengthen that rather than amend it in any way. So this kind of calls towards, I suppose, a more stringent testing of the failing firm doctrine. So I thought that the paper presented very useful findings on the analysis of 3 recent mergers to show, or rather show that it didn't use reorganization criteria as one of the legs to the tests. Thabiso has talked about the 3 mergers that were chosen. He went into detail of the types of measures that were used around financial decline, the efforts to find alternative buyers, etc. And then he explained how the reorganization test wasn't really, it's not something that the merging parties put forward readily. And he alluded to the fact that that might be because it's typically associated with the US's Bankruptcy Act. I think quite a strong contribution of the paper was how our Companies Act has provisions that are synonymous to the US Bankruptcy Act, which could also be a way in which we test whether they really have tried to reorganize the business in the best way possible under the circumstances. And once again, it's potentially a good way to make it more difficult for opportunistic mergers. And this is a point that perhaps could be made stronger in the paper. But my question to the authors is, have they considered what the cost of this would be for the failing firm? Is it, are they, given the time pressures and the environment that we're in, having to show that they've been through sort of the process of business rescue or however it's phrased in the Companies Act? What does this mean in terms of costs for the failing firm that further damages its position? And also, what does it mean for the time delay that something like this might cause? And then moving to the third paper around the failing firm or failing industry, and using the ostrich case study to illustrate this. So when I saw this paper, I was very excited because it's an interesting, and it's a very real concept that we are going to face. An entire industry is failing. So I was very interested to see the author's view on how do we deal with this. And I think they raised some very important points about how do you treat it in a declining industry situation. And the cases that they've relied on, actually, I think in my reading of it, I only found one case that kind of talks about the declining industry concept, and that was the CTP case that was spoken about. Some of the other cases in that section don't, to me, really speak about how do you treat a failing firm in the context of a declining industry. And I think that was what I was really looking for when I went into the paper, was to try and get insights on actual declining industries and how this is treated. The kind of gist of this paper, as Kali said, is not to use merger control as a tool to sympathize with parties, and rather to resort to alternative tools such as exemptions. And in her presentation, she mentioned industrial policy tools as well. I think the paper doesn't go into any more detail around what these alternative tools are and what they could look like. And perhaps that's something that the authors might consider adding a little bit more about the different alternatives that are available. Again, it's somewhat different spirit to the first paper, which talks about how the provision should be amended versus this one talks about a more stricter or more stringent evaluation criteria. Then I think with respect to the actual assessment done on the Klein Karoo and Maastricht merger, the authors tried to, or showed that, had more rigorous assessments been done, for example, the upward pricing pressure test and the gross upward pricing pressure index tests, it might have helped with issues around understanding the competitive effects of the firm. But I'm not sure this really adds much to the failing firm issue at all. And I don't think it adds much to the failing industry analysis at all. What it does do is that it highlights that there are tools out there that can be used for more rigorous merger evaluation, whether the sector is or the industry is in crisis or not. And certainly if the Commission has such information available, especially in markets with differentiated products, it would be useful to employ these tools. So in the paper, I don't see the link between doing these tests and how that links to a failing firm or failing industry, except that it can provide a more rigorous assessment of the competitive effects. And last but not least, the paper on merger threshold determination. And I think this again, it's such a rich paper. There's so much information about the different things that need to be considered when we're determining merger thresholds. And again, it evaluates a much more fundamental issue in merger control, and that's that of the optimum thresholds for merger notification. Again, this is not limited to failing firms, and it's not specific to the pandemic, but of course, the pressures that the pandemic puts on the Commission, on the Commission's resources, is of course very relevant to how the thresholds are set. So I think an extremely important topic because of the seriousness of the outcomes of incorrectly setting merger thresholds. You set the threshold too low, the Commission is going to be inundated with mergers that it has to investigate, and mergers that don't really need a substantial amount of resources because it's unlikely to have anti-competitive outcomes. And this, of course, has costs both to the merging parties and to the Commission. It's wasteful. But you set the threshold too high, and there's a risk that potentially problematic mergers are not notified. So your type 2 errors. And I think from my reading of the paper, the authors place more emphasis on this type of error for the South African economy, given our very high levels of concentration. So you have a very delicate balance, especially because these effects move in opposite directions, and the competition authorities have to come up with an optimum level to reduce the number of notifiable mergers, at the same time not sort of leave out or mergers slip through the cracks that have significant competition and public interest concerns. So Samantha has talked about the methods that were used, comparison of international jurisdictions and how they've approached threshold determination. She talked about the World Bank study. And I did have some questions on the assumptions of the World Bank study. It's not something we went into detail here in the presentation, but I think there were, there were two charts that showed that as GDP size increases, thresholds increases, or projections of thresholds increase. And I thought this was not particularly surprising because I'm sure many of the countries set their thresholds based on GDP levels or projections in growth of GDP levels. The paper also duly acknowledges some of the limiting, perhaps, assumptions of the World Bank approach, in that the countries that they've selected are based on the type of metrics used in the threshold calculation, and not necessarily countries that have similarities with South Africa from an economic characteristic perspective. So I think you duly acknowledge that in your paper, and I think that's an important acknowledgement. And you duly acknowledge that there are nuances that need to be considered when you are doing this exercise. But I suppose ultimately the contribution from the World Bank paper was that our thresholds are too low. This was the contribution, and suggestion that quite sort of really high increases would be warranted. Then I had on your particular comparison of when you did the international comparison, I wasn't very sure what the methodology behind that was. And I may have missed this, it may have been in one of the footnotes, but I think that needs to be clearer. So how did you choose the countries that, to compare? And I'll just note for the benefit of the participants, the difference between the Commission's comparison and the World Bank comparison was that the Commission used absolute measures of thresholds, so not relative to GDP, as the World Bank did. So I was just interested in understanding which countries were used for starters. Was it the same list as the World Bank, or did you have a different set of countries? And what were some of the selection criteria over and above just having similar asset and sales requirements? So that's something that I think you can clarify. But again, I get that the point was they both show that our thresholds are too low. Then I think the one section of the paper that brought in a really rich source of information was the section around your descriptive statistics. When you looked back at the 1,000-odd mergers from 2016 to 2018, and the kind of insights that gave on the burden that the Commission faces with regards to number of mergers filed and analysts per merger, etc. So I thought that was extremely insightful and something definitely that is of great interest in this particular community. And it also provides some very valuable guidance on weighing up. If you are doing a weighing up exercise of what new thresholds should be, I think that provides a very, very valuable guidance. I was a little bit confused in some of the figures that were presented, and I'm just trying to be conscious of time. Just to put it very, very quickly, there were times when it said mergers that require in-depth review were quite high relative to total mergers. I think that was in table 4, it was around 50%. And then in subsequent figures and tables, it suggested that mergers that require in-depth review were a lot lower. So I was concerned about that. but that might just be a clarification thing. To end, the recommendations that were made were really interesting, particularly around the development of sector-based thresholds. And I wished that the paper went into a little bit more detail about that. I mean, this brings in problems of creeping mergers in particular sectors, for example, and how a sector-based approach might alleviate that. So I think that was an area you can develop. It just comes in the conclusion. I think it can be developed. Similarly, your concept of transaction value-based mergers. So I think overall an excellent paper. I didn't get a sense that the authors took a view at the end, a very strong view on what merger threshold increases should be. It might be interesting to have an idea of what your view was ultimately of what it should look like. And with that, I will stop. We are out of time and there are some questions from the audience. If there's any comments that the authors and the presenters would like to make briefly, please feel free to do that before we move to the Q&A session.
Irina, thanks so much for the feedback. I think I can see the questions that are coming through on my paper, and also to address the questions that you raised in very, very detailed feedback. Thank you for that. So the first point that I'd like to make is that we shouldn't loosely use the word defense for the failing firm. It is a doctrine, and in South Africa, it's part of the SLC inquiry. It's not an absolute defense. That's the first point that I'd like to make. And then I see a question about merging parties are suggesting that the failing firm defense renders them immune to public interest conditions. So if I just want to take you back to section 12A2, and that is the competitiveness assessment. And the doctrine is imbibed in whether the business or part of the business of a party to the merger or proposed merger has failed or is likely to fail. So there is EU law where a part of a business failed, but the entire business did not fail, and that was found to be a failed firm. And also, Iskor Saldana does answer the question of whether you can incorporate a failing firm doctrine in your public interest or efficiency inquiry, and the answer is simply no. So the first point in that 7-point criteria that you'll find in our paper and in my presentation, they put forward the position that a failing firm defense should not be invoked if it amounts in substance to another factor or defense which the Act already provides for. And in particular, they drew attention to the efficiency defense and public interest criteria. So that also answers the second question that I can see on the chat. So would my assessment under the SLC differ if it was able to be justified on a public interest ground? Those are two separate inquiries. So how the failing firm doctrine and how it's applied under the SLC, you can't double dip. You're going to have to pick one. And that's why we were very careful in the paper to differentiate between the doctrine and the effects of the failing firm. So employment does then fall under public interest. So a firm may choose not to raise section 12A2G because it's better assessed under public interest, and then they're falling within the ISCOR guidance on that. So it's just about differentiating that and balancing the weighting. So currently our legal framework does allow for a delicate balancing exercise. And you did mention that if we go with the last recommendation in our paper about amending the legislation to become really rigid, and that is when I was preparing for this presentation, that is the one thing that popped into my mind this morning, that actually the better approach and a more direct, immediate approach is for the Commission to use the legislation and place more weight on the factor that 12A2G versus the long-term effect of having too rigid a legal framework. But I think the point of the paper was just to pique some interest, start a dialogue. No one recommendation is better than the other. We would just like the doctrine to evolve. And yeah, we don't want to cause any rigidity. There's no one size fits all. And we must always just be guided by the preamble of the Act. So we want to achieve an efficient and effective economy. And our purpose is to promote and maintain competition in the Republic. And also our vision is for growing an inclusive economy. So, when I thought about it again after writing the paper this morning when I was preparing, the best way is our first two suggestions. More weight on that factor in the SLC assessment, and then looking at guidelines just to provide some sort of certainty as to what documents to provide. And if in our paper, if you read through, then you'll see that it's sometimes there's not a specific test that's applied, but it's just evidence that's put forward to the competition authorities. So yes,
Thanks, thank you. Just to give some of the other authors a chance, we are running out of time. If there's any comments or responses to some of the questions I've raised, please go ahead. And I think there are a few more questions from the audience.
Irina, thanks very much. Thanks for the question. But just a quick one on the costs. Yes, it would amount to costs going into business rescue. However, those costs, they don't have to be expenses in this financial year. They can of course be delayed and paid and recognized as a provision, and then they just reported as a liability in the financial statements. We shouldn't have too much effects on the financial statements of this year, and it shouldn't result in any losses or expenses. Thank you.
Thanks, Tabiso. If there are any closing remarks from Kali and Samantha?
Thanks, Rina. There's really nothing from my side except to thank you for the contribution. And also, I take note of your comment saying you were really looking forward to seeing what has been happening with failing industries. And that's actually what we were also trying to do. But unfortunately, we couldn't find any case precedents. And I think what we should be doing going forward to develop the paper is to look at international case precedent. Thank you.
Thanks, Kali. Samantha?
And thanks, Rina. We'll take your comments on board. They're actually really, really good suggestions as well. In terms of the country selection, so part of our initial setup when we were looking into this paper, we also had a look at various different countries and how they set up their thresholds. And this kind of led us to kind of select the countries that were most similar to ours. And we went from there. So the initial paper, not this conference version, is actually quite a lot more detailed, and it goes into quite a lot of specifics on the types of metrics that these countries look at and why they might have chosen these particular metrics. And yeah, so in terms of ultimately the ones that we do show in this conference paper, they're just based on how similar they are to us. Not necessarily in terms of size, but we've also then converted their thresholds to a common currency so we can compare. And as the World Bank does, they then compare it relative to economy size to make it comparable across the board.
Thanks, Samantha. And I do think that sector-specific threshold is a really interesting idea and one that's useful to develop. But thank you very much. I think we are out of time and a little bit over time. Just a big thank you to the speakers. And as I said at the beginning, these are papers that definitely should be read. There's a lot of detail in there. And I think it's very interesting and very topical issues, of course, that are presented. So thank you once again to all the speakers. I really enjoyed reading your papers. Please feel free to speak to me for some of my more detailed comments that I haven't been able to put forward today. Thanks very much.
Thank you, Rina, for moderating that session so well. And before you go, let me say many, many, many congratulations on getting your PhD. I know, blood, sweat, and tears. Okay, I don't know because I don't have any experience there, but I've seen people who like to torture themselves. And there is a lot of blood, sweat, and tears. So congratulations to you on getting your PhD.
Thank you, Nandi. Thank you.
You're welcome. You're welcome. Thank you also to all the panelists who represented the Commission so well. Of course, the problem with this is that next year we might see you representing CRED or Genesis or the law firms. I hope Rina is listening. So maybe the Commission needs to raise its own barriers to entry here or barriers to exit somehow. Thank you guys for representing the Commission really well. Okay, so from flailing to fading to failing firms, we're going to break for lunch now. Please join us at 2 o'clock for our last plenary session for the day. It's going to cover a really hot topic nowadays, and that is the intersection of competition and consumer laws. That's both in the COVID context and beyond COVID. So that session is going to be moderated by Yasmin Karim, and she's got an excellent panel that she's going to introduce to you. Please be back with us at 2 o'clock. Thank you.